3, 2, 1. Hey guys, welcome back to my channel. So today I'm going to be taking law of tort, and under tort we're going to be talking about negligence. So I want you guys to listen to what I have to say about negligence under the law of tort while I do my full note makeup. Get ready with me as I teach you what negligence is. So I'm going to be doing my full nude makeup. First of all, I'll be using my aloe vera infused cleanser for my face. So guys, today, like I said earlier, we're going to be talking about negligence under the law of tort. Before I start, I would like to explain some things to you at first, in case you don't know much about law, or probably you're not a law student or something like that. So first of all, I would like to explain to you plaintiff, what a plaintiff is. Who is a plaintiff? According to Google, a plaintiff is a person who brings a case against another person in court. So the person who brings the case to court is referred to as the plaintiff. So that is the first term. The second term is defendant. Who is a defendant? A defendant is an individual, a company, or an institution sued or accused in a court of law. That is, the person sued is the defendant. I hope you get me. So I bring a case against you in court. I in law will be referred to as a plaintiff. You trying to defend the case will be referred to as the defendant. I hope you get the term. Okay guys, so I like to use my primer first. So my primer is this Elegel Pro Prep. So to continue my story on negligence, I'd like to explain to you the term called court too. What is court? What is the definition of a court? So a court is a body of people presided over by a judge, judges or magistrates, and acting as a tribunal in civil or criminal cases. So basically what a court is a place where people gather that is presided over by a judge. Do you understand me? So it is in a court that the plaintiff and the defendant means to present their case. Negligence in tort means omission to do something which a reasonable man would do or not do. So negligence is probably like an act, an omission to do a particular thing you're supposed to do. I hope you get me. So when you refuse to do it, then we can say you are negligent. When you have refused to do what you're supposed to do, or you refuse to act in a particular way you're supposed to act, or you decide to omit what a particular thing you're supposed to do, we can say you're negligent. So negligence is the breach of duty to take care which results in a damage undeserved by the defendant to the plaintiff. So guys, so negligence in tort means to omit a particular thing you're supposed to do, and or not doing a particular thing you're supposed to do. So now, unlike intentional tort, where the defendant deserves the consequences, it is undeserved damage to the plaintiff. That is, negligence is you refusing to act in a particular manner in which it causes damage to another person, and this damage is not deserved by the person. It is undeserved. That is why we call it negligence. Now, however, there's some things you have to prove in court before you can establish that there has been a negligence by a particular person. That is, when you get to court, you have to prove some certain things, and the number one thing you have to prove is that there's an existence of a duty of care. That is, you cannot go to court and say that I've committed a tort of negligence against you if I do not owe you any duty of care. So the number one thing to prove negligence in court is that there must have been a duty of care. The number two thing is that there must have been a breach of that duty of care. That means it is not enough to have a duty of care alone. It is not enough to owe me a duty of care alone. You must have actually breached that duty of care which you owe to me. I hope you're getting me. You must have actually breached the duty of care. Then the last one is that it must have resulted in a damage. There must have been a damage by you breaching your duty of care. So now I want you to understand something. The development of torts, the tort of negligence, is categorized into three main parts. The development of torts is actually categorized into three main parts, and the first part is negligence was merely a component of other torts. That is, before the first phase of negligence as a tort itself, it was just merely a component of other torts put together. It is part of other torts. It was not just a tort on its own. Another phase is that negligence developed into action on the cases, and this saw the beginning of negligence as an independent tort. So before it started with just a component of other tort, thereby graduating into an action. And the third phase is started from the decision of the court in the case of Donoghue against Stevenson. I am going to be explaining the facts of that case to you very soon. The case of Donoghue against Stevenson. Okay, so in this case, negligence was, fully recognized and as an independent tort capable of extension into a new category. That is why negligence starts to, negligence now became a tort on its own, and you could bring an action in court for negligence. In the case of Donoghue and Stevenson happened, this particular type of negligence happened in the year 1932. This was a case decided on in the year 1932. And what happened in the case of Donoghue versus Stevenson in the year 1932 was that a manufacturer of a ginger beer sold his product to a retailer. However, this retailer resold it to a particular man. The retailer resold the product to a man, and this man had a girlfriend. Then the man didn't take it himself, from the manufacturer to the retailer. The retailer sold it to a consumer, and the consumer did not consume it. He actually gave it to his girlfriend, his lady friend, according to the facts of the case. So he gave it to his lady friend to consume. The lady friend had consumed almost all of the beer, the ginger beer, when she noticed that there were decomposed remains of snail in the beer. Can you imagine? A dead snail was inside the beer. However, she became so sick. She couldn't see it at first because the bottle is opaque, like something like a dark brown bottle, so you cannot see what is inside. It was when she wanted to gulp, take the last part of the drink, pour it inside a cup, that she saw the decomposed beer, and the decomposed snail inside the beer. Then she became so sick from this that she was hospitalized, and she sued the manufacturer of the beer for injury, because the manufacturer, however, claimed that she couldn't bring any action against him because there was no relationship between them. He didn't sell it to her. She wasn't the final consumer that bought it from the retailer. And however, that the plaintiff is now entitled to an action in court. I hope you are getting me, because the lady didn't buy it directly from the retailer who bought it from the manufacturer. The manufacturer was standing his grounds that there was no contractual relationship between him and the lady. Thereby, the lady cannot bring an action against him. That is really bad, isn't it? However, the court held another thing entirely. The court held that nonetheless, the fact that there is no contract, she is entitled to bring an action against the manufacturer in tort, because obviously the action was not based on contract, and there was no contract between them. But in tort, she can actually bring an action against him. I hope you're following. So, however, one of the presiding lord, because then we had law, not judges, over the case of Donoghue against Stevenson is Lord Atkin. So, he however said that you must take reasonable care to avoid acts or omissions which you can, reasonably foresee would likely injure your neighbor, and as to who is your neighbor. So Lord Atkin was mainly saying that you must actually always take care. Look at your acts or your omissions. If it is something you will do that will injure your neighbor, then don't do it. Do you understand? So, however, here the question was now asked in court that who is your neighbor? Guys, that is the question of the moment at that particular point in time. Then who then is my neighbor? Since you're saying that I must always make acts or omissions that would necessarily injure my neighbor, then who then is my neighbor? I hope you're getting me. So Lord Atkin continued in what he was saying, and he said that your neighbor-in-law include those persons who are closely and directly affected by your act. So, that what I'm saying here is that Lord Atkin was of the opinion that, okay, since you said you don't know who your neighbor is, I am going to explain to you who your neighbor is. And according to Lord Atkin, he said your neighbor-in-law include those persons who are closely and directly affected by your acts, that you ought to, reasonably have them in their contemplation. For example, your let's say your neighbor has a dog. He has a dog that eats fresh food. Then you now decide to put a poisonous fish. Yeah, the dog is going to pass through your door. You now decide to put a poisonous fish outside your door and say, oh, you have plans to throw it away, but then you want to keep it outside your door at first. You reasonably, as a reasonable human being, you know that dog might get there, eat it, and the dog will die. Do you understand? However, the neighbor we are talking about here, are you getting me? It doesn't mean those close or next to you, or those your neighbor here doesn't mean those closer or nearest to your family members. But your neighbor here means that those that you foresee are likely to be affected by your carelessness or by your acts and omissions. Those are referred to as your neighbor. So then, where the neighbor's principle emanated from? It is from the Donoghue and Stevenson case. That is where the neighbor principle emanated from. Okay, so as I was saying, your neighbor here doesn't mean who do you categorize as your neighbor? It doesn't mean, literally the person who lives next door. No. A neighbor is someone who is affected directly or indirectly by your acts or omissions. So your neighbor can be any person anywhere in the world. That is what the law says. Your neighbor can be any person anywhere in the world who your acts or omissions affect them or are likely to affect them. I hope you get me. So the defendant owes the duty. The neighbor principle is mainly contained to expand and cover different categories. The court is, however, saying that when there is a reasonable foreseeability of injury, the defendant owes the plaintiff a duty of care to ensure the plaintiff does not suffer such injury. I hope you get me. So it was not referred back to the case of Stevenson and Donoghue that here it was saying that there is no contractual relationship between you and the lady. But however, she consumed your product. She has become your neighbor one way or the other because she's directly affected by your act and your omissions. It's probably an omission for getting a decomposed snail inside your beer bottle. Are you getting? However, the rule in the case of Donoghue against Stevenson, there are exceptions to the rule, which covers So guys, as I was saying the other time, however, as good as this case of Donoghue and Stevenson is, there are major exceptions to this rule. The major exceptions to the rule in Donoghue and Stevenson, and this is based on justification and valid explanation and policy reasons, and because of this, the courts may, give negative or reduce the limits of the scope of the duty owed by the defendant to the plaintiff. So in the case of Osemobo against Niger Biscuit, which is a Nigerian case, and this case was decided on the year 1973. In this case, the plaintiff was eating some biscuits, was just enjoying a good, beautiful, smelling, nice biscuit, which he bought from a shop. However, it felt an hard object. And in the biscuit, he decided to remove the hard object in the biscuit. In the biscuit, he found a decayed tooth embedded inside the biscuit, like a decayed tooth of a human being. The plaintiff became really ill, and he sued the manufacturer of the biscuit. And the court held that yes, the manufacturer owed a duty of care to ensure that the plaintiff does not suffer harm as a result of using the defendant's goods, which is obviously the duty of care. So, as I said earlier, for there to be an action in negligence, for such action in negligence in court to succeed, you must prove that the defendant has breached the duty of care. It is not enough for you to explain that there is a duty of care owed by the defendant to you. The defendant must have actually breached this duty of care. So, in other words, he has not done what he's supposed to do in a particular way he's supposed to do it, or he has actually done what he ought not to do, or what he did and he was supposed to do was done negligently. Also, in the case of White against Basil, this case was presided on in the year 1916, and it was reported in the Nigerian Weekly Law Report, Part 1, page 26. Okay, so in this case of White against Basil, there was a motorist who was driving along the road on a rainy day. However, the people who saw him driving along the road on that rainy day had previously said that yes, the man was not rushing, and he was on a very, very beautiful good and average speed. It wasn't even careless with his driving because it was raining and it was almost dark. So, however, a 5-year-old boy ran into his car and it knocked down the boy. The court held that the motorist had a duty of care to ride carefully along the highway, number one, and also to actually ride carefully along the highway where because it is raining. Do you understand? So in this particular case, since he had done what he was expected to do under the circumstances, the court held that yes, he did what was right and that he cannot be held negligent. So what am I saying? What I'm saying is that for there to be for a tort of negligence to be brought against you, there must have been a duty of care. The duty of care must have been breached, and it must have resulted in a damage to the plaintiff, just like the case of Basil and White, where he found a decayed tooth. That's the magic. He found a decayed tooth in his biscuit, which is bad. Like, let's be realistic. That is bad. Why would I be eating a biscuit and find a decayed tooth? Like, for God's sake, right? You to understand something, like defendant to be held negligent if he acts below the standard of a reasonable man. So, however, what is the standard of a reasonable man? That is the issue before the court. That okay, you are saying that it should not act like it should not act below the standard of a reasonable man. Then what is the standard of a reasonable man? Because I can just come up and say that, oh, what you did right now is not reasonable. Do you understand? And someone else might see me as reasonable, someone else might not see me as reasonable. So what is the standard, of a reasonable man? However, the court was of the opinion that for it to measure the standard of a reasonable man, then there's something we call the Rook factor. The Rook factor has 4 elements to decide whether you've acted in the standard of a reasonable man or not. So stay tuned, as there will be a second part on the law of tort. So we will start from the Rook factor. I hope you enjoyed this video. Don't forget to subscribe and give this video a big thumbs up. You can share with some of your friends that are law students or something. You can decide to share with them, and then don't forget to subscribe. Subscribe. Do not forget to subscribe, please. Subscribe to my channel. Give this video a thumbs up. So guys, that will be the end of today's class on, I hope you like my week, on the law of torts, negligence topic to be precise. I hope you give this video a thumbs up, like and share this video, subscribe to my channel so that when I bring other content, you would be able to get a notification of that. All right, bye. I hope my video helped you on your negligence. Bye.